I wrote Climate Change on Trial because we usually don't take the time to take stock of movements and litigators and advocates' achievements as they do the hard work of representing clients, of working with social movements, with indigenous leaders. And this is an effort from the point of view of someone who's been both a practitioner and an analyst of the field to make this story understandable and tangible to practitioners and scholars around the world. I've worked in places like Bangladesh, like the Amazon, like the Caribbean, and I've seen firsthand the consequences that climate change has on those vulnerable communities and individuals. The human rights legal apparatus and the human rights story is particularly efficacious when it comes to bringing the abstract concept of climate change down to the level of those individual and collective impacts. The future of human rights-based climate litigation will be heavily informed by two recent landmark decisions by the ICJ, the International Court of Justice, and the Inter-American Court of Human Rights from 2025. Those two decisions consolidated the incremental body of standards and law that was developed by a whole range of institutions. What they all did was bring together these otherwise parallel, separate tracks of legal creativity and legal activity, and by bringing together human rights and climate change law, we now have a body of rules and principles that in the future can be deployed in new cases having to do not just with mitigation, with the reduction of carbon emissions, but also with adaptation and climate reparations. The 20-year story that I tell in the book, based on interviews and a comprehensive analysis of the cases that have been brought before courts and human rights bodies around the world, that is a success story to a large extent. We need to be as flexible and as creative as the field has been over the last 20 years, and that means creating connections between climate litigation and biodiversity and pollution litigation and policies. It's not just about litigation. Litigation is just one potential tool. What is equally needed is progress in terms of economic policies, in terms of climate negotiations at the global level, and every other tool in the legal toolkit to advance climate action as fast and as urgently as possible. Young people have already had a major role in rights-based climate litigation and action. Many of the cases that I document in the book were led by young people. Now, going forward, in addition to continuing to mobilize for climate action, scholars and practitioners will need to find ways to bring together the new standards and the new rules and principles that have been developed by not only domestic courts, but also by regional peak courts like the Inter-American Court of Human Rights or even the ICJ, the International Court of Justice, to take all of that legal stock and bring it into conversation with efforts to protect rights of nature, to protect the oceans from plastic pollution, a whole range of legal actions that are adjacent to the effort of climate change. And in fact, those efforts are interrelated because we all are embedded in the biosphere. We all are part of the earth. So climate change cannot be set aside as the existential challenge that needs a specialized attention and unique focus. We, and especially younger lawyers and students, will need to develop more holistic interpretations of climate action that create bridges with lawyers and practitioners in the fields of rights of nature, biodiversity protection, plastic pollution, and many other lines of environmental and human rights work.